Lordships, the current session is streaming live on YouTube from now on. Shall we let in the participants right now?
Yes.
Your Lordships, welcome to the first international Moot competition conducted by His Highness Maharaja's Government Law College at Ernakulam. If your Lordships are ready, we'll begin with the session.
We can start. We can start subject to what Viju and Ari say.
Yes,
Yes, your Lordship.
yes, we can start.
Welcome team 104 and 113. If the teams are ready, both teams may please convey your time accordingly.
IMC 104, speaker 1 will take 20 minutes, whereas the speaker 2 will take 23 minutes and 2 minutes for rebuttals. Thank you.
Noted. And IMC 113.
IMC 113, speaker 1 will be taking 22 minutes, speaker 2 will be taking 22 minutes and 1 minute for rebuttal. Thank you.
Okay. So the time apportionment of team IMC 104 is 20 minutes to speaker 1, 23 minutes to speaker 2, and 2 minutes for rebuttal. And in case of IMC 113, speaker 1 will take 22 minutes and speaker 2 22 minutes and 1 minute for rebuttal. Hope it's clear. Once again, with the permission of the Lordship, we'll begin with this.
Yes.
Thank you, Your Lordship. Good morning, everyone. It's our esteemed privilege to have with us our panel of 3 eminent judges, Honorable Justice Gopinath P, Honorable Justice Viju Abraham, and Advocate Hari Narayan. Welcome, judges. We're delighted to have you here. And this is the most awaited round of finals of first international Moot Court competition conducted by His Highness Maharaja's Government Law College at Ernakulam. For the attention of the judges, we have here team code IMC 104, consisting of speaker 1, speaker 2, and researcher representing the petitioner side. IMC 113, consisting of speaker 1, speaker 2, and researcher representing the respondent sides in the case. I hope the teams are familiar with the rules. Both teams have 45 minutes each for their presentation. IMC 104, speaker 1, you have 23 minutes. Speaker 1 will have 20 minutes, speaker 2 23 minutes, and rebuttal time 2 minutes. 113 will be having 22 minutes each for speaker 1 and speaker 2, and 1 minute for rebuttal. There will be a warning given for half time, and when there is 5 minutes, 3 minutes, and 1 minute left for the session, sorry for the speaking time. When the time allotted is over, a message will be put up in the chat box, followed by an audio command. Make sure all the participants are adhering to the rules and are monitoring the chat box thoroughly. Regarding the display of compendiums, the speakers may request the court officer for the same with the permission of the court by referring to the page numbers and paragraphs. If your lordships are ready, I would like to invite the first speaker for the petitioner to speak. Speaker 1 is allotted 20 minutes of time. Speaker 1, IMC 104. Your time starts now.
The council seeks permission to begin with his oral submissions, Your Lordship. Much obliged. The council seeks permission to refer this learned bench collectively as Your Lordships. Warm greetings, Your Lordships. May it please the court, this is council number 1 representing the petitioners in the instant matter of Octa Limited versus owners and parties interested in MV Moonlight. Council over the course of next 20 minutes shall be dealing with the substantive issues of the case that are issue number 1 and 2, whereas my co-counsel will be dealing with issue number 3, 4 and 5. The council submits to the jurisdiction of this Honorable Mumbai High Court under section 4 subclause F of the Admiralty Jurisdiction and Settlement of Maritime Claims Act 2017, which permits the High Court to exercise jurisdiction to hear and determine any question on a maritime claim against any vessel arising out of any loss or damage to or in connection with any good. Now, if your lordships are well versed with the facts of the case, the council seeks permission to move on to the arguments advanced.
Yes.
Much obliged.
Yes.
Your lordships, the council shall address the first issue in 2 parts, that is the international perspective and the Indian law. Firstly, the council shall touch upon the international conventions on maritime jurisdiction, which allows the domestic high courts to exercise jurisdiction over foreign seated arbitration tribunals. Your lordships, it is humbly submitted that in the absence of any comparable provisions in the Admiralty Act of 2017 regarding a right to file an admiralty suit to arrest a ship as security for foreign seated arbitrations, the Supreme Court in cases like MVC Success has always taken the assistance of international conventions to deal with the extent of jurisdiction of admiralty courts in India regarding foreign seated arbitration proceedings.
Before you go into the conventions,
Indeed, Your
I have a question. See, what is your claim for? It's a claim for short delivery of cargo, right?
Indeed.
So you are instituting the suit under the charter party or under the bills of lading?
Your lordships, under the charter party.
Under the charter party. So the claimant has dual role, one as a charterer and as a consignee under the bills of lading.
Indeed.
So it's almost certain from the facts that goods were short delivered, 650 metric tons were short delivered. So is it not a simple case of claim for short delivery of cargo? Why are you connecting it with arbitration?
Your lordships, the very reason for connecting it with arbitration is that the respondent's claim is that there is an arbitration clause in the charter party which says that any claim for journal average is to be referred to arbitration.
True. That is under the charter party. That is under the charter party. Now, coming to your claim, that's why I asked whether your claim is under the bills of lading or under the charter party. If it is under the bills of lading, you need not refer to arbitration at all.
Indeed, Your Lordships. But it is under the charter party because the charter party includes the arbitration clause, which the respondents are referring to as that it should be referred to arbitration. Whereas our claim is that this honorable court has the right to exercise its jurisdiction in the present case.
Does the bill of lading provide for any different mode of resolution?
No, Your Lordships. No other.
What we are asking is because the claimant is also the consignee of bill of lading.
Indeed, Your Lordships. May the council proceed?
Yes.
Indeed. Your Lordships, in the Supreme Court, in the cases like that of any success, has always taken the assistance of international conventions to deal with the extent of jurisdiction of admiralty courts in India. The international conventions that deal with the extent of jurisdiction of admiralty courts in India regarding a foreign seated arbitration proceeding and has always observed that where no statutory law operates in the field, interpretive changes must be made having regard to ever-changing global scenario. Now, if your lordship could refer to page number 1 of the Moot Court Memorial on behalf of the claimants, the point number 3 states the Article 7, subclause 1, subclause B of the International Convention relating to arrest of seagoing ships.
Is that convention ratified by India?
No, your lordship, that has not been ratified by India.
So we have a domestic statute in India which now governs the arrest of ships, which is the Admiralty Act of 2017. So what does that act talk about? A scenario where there is an international arbitration going on between the parties.
Your
Can
lordship,
an arrest be possible?
The Admiralty Act does not touch upon foreign-seated arbitration proceedings. That is the reason it is important to refer to conventions, as has been referred in many Supreme Court cases.
Now, all the Supreme Court cases were prior to the Admiralty Act of 2017. Now, after 2017, was there any change in the situation? Can you refer to any judgment subsequent to the new statute?
Your lordships, there's no such judgment that touches upon basically the foreign-seated arbitration with the council as of now. But there's no comparable provisions in the Admiralty Act of 2017. Hence, it is important to refer to the international conventions.
Is arrest possible to get security for an arbitration under the 2017 Act?
Your lordships, the 2017 Act does talk about the in rem and security of under the arbitration, but in the present case, it is an international seated arbitration.
Now, can you read the relevant provision under the Admiralty Act? I mean, under the Admiralty Act, which deals with arrest, which is a provision.
Indeed, your lordships. The section 4 subclause F of Admiralty Act states that
that is a claim. The arrest is under section 5.
Indeed, your lordships. In rem arrest is under section 5.
Yeah, what does it say?
Just a second.
Does it say an arrest is possible to obtain security for an arbitration award? Or is it the the security for the claim that you raised in the Admiralty proceedings?
Your lordships, the section 5 states that the High Courts may order an arrest of a vessel which is within the jurisdiction for the purpose of providing security against a maritime claim. Yeah,
against a maritime claim. So where is it that you can arrest the vessel to obtain security for an arbitration award?
No, your lordships, there is no arbitration award in the present case. The arbitration proceedings haven't even started.
Yes.
It is a maritime claim of general average.
No, but you are referring to arbitration.
No, your lordships, the contention by the claimants is that the case should not be referred to arbitration.
It can be tried by the Admiralty Court.
Indeed, your lordships. This is the contention of the petitioners in the present case.
Okay.
Now, if your lordships could refer to the two conventions that have just been cited by the council, the first one being the Article 7, subclause 1, subclause B of the International Conventions relating to arrest of seagoing ship. It states that the courts of the country in which arrest is made shall have the jurisdiction to determine the case upon its merit if the domestic law of the country in which the arrest is made gives jurisdiction to such courts. In any cases, namely, if the claim arose in the country of which the arrest was made. Now, lordship, similarly, in the present case, the section 4 subclause F of the Admiralty Act permits this High Court of Mumbai to exercise its jurisdiction to hear and determine any questions on a maritime claim against any vessel. Now, lordships, furthermore, the fourth point on page number 1 of the arguments advanced, the International Convention on Arrest Going Ships, 1999, Article 2, subclause 3 has been cited. If you could refer to it.
Yes.
Now, lordships, this convention states that a ship may be arrested for the purpose of obtaining security, notwithstanding that by virtue of a jurisdiction clause or an arbitration clause in any relevant contract. Now, lordships, this article of International Convention of Arrest Going Ships explicitly allows the arrest of a vessel by any court to obtain security regardless of the fact that there exists a clause in the contract directing any future disputes to be adjudicated in any other court or under any other law. Your Lordship, the convention contains lucid provisions allowing parties the right to initiate an action in rem on pending foreign seated arbitrations. Hence, Your Lordship, it can be rightly stated that these two conventions unequivocally authorizes the arrest of vessel and other similar properties under this Honorable High Court's Admiralty jurisdiction.
Yes.
Now, Your Lordship, the Council seeks permission to move on to the second submission, that is the Indian perspective. Much obliged. Now, Your Lordships, in the second limb of the argument, it is humbly submitted that the Arbitration and Conciliation Act of 1996 does not house the jurisdiction of a civil court. The Section 9 of the Arbitration Act states that a party may, before the commencement of arbitration proceedings, apply to a court for interim measures. The subsection 2 lists down that a party may apply for interim measure for the detention of any property which is the subject matter of a dispute in arbitration. Now,
Is
citing
detention and
a,
arrest one and the same?
Your
Is
Lordship, could you repeat?
detention and arrest one and the same?
Indeed, Your Lordship.
It is, according to you.
Indeed.
Okay, so does an arbitrator have got a authority or power to arrest a vessel as an
No,
interim
Your
measure?
Lordships, the Admiralty Court has the right. As per this law, it states that this Honorable Court has the right to right of detention of any property. The detention of the property in the present case being the vessel. Indeed, Your Lordships. Now, Your Lordships, citing a very important case in this regard by this Honorable Mumbai High Court, that is the JS Ocean Liner versus MV Golden Progress. It was rightly concluded in that case that a vessel can be arrested and the detention can be made under the Admiralty jurisdiction of the court, even if an arbitration proceeding with a foreign seated arbitration exists. The Honorable Court observed that an action in rem as an Admiralty suit for recovery of maritime claim and arrest of vessel in exercise of Admiralty jurisdiction can be maintained even if there is an arbitration agreement. Hence, Your
No,
Lordships,
what is decided by the Bombay High Court in that judgment? It only said that for the limited purpose of obtaining a security, you can arrest the vessel, and once
Indeed.
the arrest is effected, then the parties will be relegated to arbitration.
indeed,
It is not that the Admiralty Court can decide the entire claim on merits.
indeed, Your Lordship.
So your claim for short delivery of cargo, how can the court decide it on merits? Because even going by the decision that you cited, the Bombay High Court judgment, it only says the arrest is given as a security, and once security is furnished, then you have to go to arbitration.
Indeed, Your Lordships.
So do you agree
Lordship,
with the objection raised by the defendant that in view of the arbitration clause, the court cannot go into the merits of the claim?
Indeed, Your Lordships. But Your
Are you
Lordships,
agreeing? Are you agreeing with
repeat?
the objection of the defendants?
no, Your Lordships, we are not agreeing with the objection of the respondents in the present case, Your Lordships.
No, but then
It is humbly-
you tell us a way how we can decide this matter on merits here.
Your Lordships, the council would like to cite another case in this regard, which is that of Altus Uber.
That
Your
of
Lordships, Altus Uber.
Altus Uber, yes. Is
Your
that
Lordships, in
the-
this case,
Hmm,
it was decided
hmm.
that an action in rem under the Admiralty jurisdiction of a court is allowed to settle a maritime claim.
We didn't get you to settle a maritime claim.
Yes, Your Lordships. The maritime claim in the present case being the claim forwarded by the petitioner.
No, see, you have filed the Admiralty suit as an interim action, which is understandable. But once the defendant appears, then it proceeds as an in personam.
No, Your Lordships, it would not. That would be further discussed by my co-counsel in the interim question that has arisen in the fifth issue.
Counsel, are you taking the plea that the arbitration clause under the charter party does not cover your claim for short delivery.
Indeed, Your Lordship.
Is that your case? Then you have to argue that. You have to say that it doesn't cover. It is regarding the terms of the charter party and not regarding the terms of the carriage of cargo or whatever you want to say.
Your Lordships, the contention forwarded in the first issue is that the jurisdiction is valid in the present case. The contention that an in rem action is not arbitrable would be dealt by my co-counsel in the fifth issue.
Yes.
Indeed, Your Lordships. My Lordships, in the present case, the arbitration proceedings haven't started and an Admiralty suit for the enforcement of maritime claim falling under Section 4 of the Admiralty Act has been filed. Hence, Your Lordships, as observed in many cases, the court shall have unrestrained power unless there exists a clear provision barring the jurisdiction of a court to settle disputes. The charter party in the present situation does not explicitly prohibit either of the parties to approach the Admiralty jurisdiction of this present court. The court, in exercise of such power, can pass interlocutory orders for arrest and attachment before judgment in interest of justice. Hence, Your Lordships, thus, after a study of comprehensive judgments, it is humbly submitted that this High Court of Mumbai has the authority to exercise its Admiralty jurisdiction in the present matter.
Yes, Admiralty jurisdiction is there for the limited purpose of arresting the vessel and obtaining a security.
Indeed.
What after that? How do we decide the claim?
Your
Because
Lordships,
it's only an interim measure to obtain security for the claim, which the High Court can grant by arresting the vessel. But where is our authority to decide the claim on merits? Your claim is for short delivery of cargo.
Your Lordships,
So how does the High
section-
Court under the Admiralty jurisdiction go into the question of disputed question of deciding whether there was actual loss of cargo or not? That is something which is provided under the dispute resolution clause in the charter party.
Now, Your Lordships, it is humbly submitted that, as observed in many cases, the High Courts shall have unrestrained power unless there exists a clear provision barring it. As stated by the Council, the Section 4 subclause F states that this Honorable High Court has the power to hear on maritime claims. Hence, Your Lordships,
What is 4F? What is 4F?
Section 4F.
Yes.
Your Lordships, the Section 4F states that it permits the High Court to exercise jurisdiction to hear and determine any question on a maritime claim against any vessel.
No, that is general. I mean, there are claims enumerated under Section 4. Your claim comes under which subsection?
Subclause F, that is arising out of any loss or damage or in connection with any goods.
Yes. So where is the charter party dispute there?
Our contention
Only
is that
damage to cargo or loss of cargo. That
Indeed.
we understood. But where is the charter party dispute which can be tried by the High Court under 4F?
Your Lordship, the charter party dispute is that the present case should not be referred to arbitration.
We didn't get
That
you.
is the charter party dispute, because the charter party includes a provision that it should be referred to arbitration.
No, what I'm asking is, under the Admiralty Act, okay, which provision says that if there is a dispute between the charterer and the owner, it can be tried by the High Court as a
Your Lordship,
maritime claim? There is a maritime claim under a charter party dispute. Is it covered?
Your Lordship, the present case is of a maritime claim, which could be lucidly tried under Section 4 of F of the
The
Admiralty Act.
loss of cargo or damage to cargo is a maritime claim. Okay.
Indeed.
Now you said there is a dispute under the charter. You said you are claiming under the charter party as a charterer. So
Indeed.
whether that dispute can be considered as a maritime claim, that is our question.
No, Your Lordship, that dispute could not be stated as a maritime claim, because the dispute is that of arbitration or not arbitration. That is the dispute under the charter party.
Okay. Continue.
Again, you have to go back to that issue of whether your present claim is within the terms of the charter party or outside it. If it is outside it, possibly there is a point in what you're trying to say that I mean the arbitration clause does not bar the jurisdiction of this court.
Indeed, Your Lordships, the
Yeah, that's
claim
right.
is outside that of charter.
Yes.
Much of it. Your Lordship, the council seeks permission to move on to the second issue.
Just one question. What is the
Indeed.
effect of Section 8 of the Arbitration Conciliation Act on the jurisdiction of the High Court?
Your Lordship, the Section 8 states that where there exists an arbitration clause, the person claiming by an application could refer it to the arbitration.
Correct. It is a kind of right given to the defendant or the respondent to say
Indeed,
that
Your Lordship.
there is an arbitration clause and therefore you can't proceed under any other. Now, vis-a-vis the Admiralty Act and all these things, which is the special law, do you think that the Arbitration Act provisions of section is not
Could you repeat the question, Your Lordships? I lost you at the end.
do you have a case that Section 8 does not apply? Because the
the
Admiralty Act gives a special jurisdiction to the High Court.
Indeed, Your Lordship.
And vis-a-vis the Arbitration Act, this is a special provision.
Indeed. Your Lordships, it is humbly submitted for Section 8 to apply. There needs to be submitted an application for the courts to refer the present dispute to arbitration before the first hearing. Your Lordships, in the present case, no such application has been provided by the respondents.
All right.
Your Lordships, if
Without
your
interrupting the court, with the permission of your lordships, let me remind the speaker that your time is over. You may seek the court's permission for granting it.
Your Lordships, the council seeks permission of 5 minutes to just sum up with the second issue.
Sure. Go ahead.
Indeed, Your Lordships. Your Lordships, in the second issue, the council humbly submits that the declaration of general average is not legally sustainable if the vessel is unseaworthy. The petitioner forwards the following arguments, Your Lordships. Your Lordships, in the most fundamental sense, providing a seaworthy vessel requires that the vessel is structurally fit for the intended voyage, which means it is also fit to meet and undergo perils of the sea and other incidental risks. Your Lordships, before it is humbly submitted that if you could refer to the page number 9 of the compendium. Point number 2, page number 9
How
of the
do you
compendium.
say that the vessel is unseaworthy? Are you referring to the physical condition of the vessel?
Your Lordships, the council is referring to the human seaworthiness aspect of the vessel. That includes the skills of the master.
Skills of the master. So so that's exactly my question. So how do you say that the vessel is unseaworthy? In what respect or in what manner you say that it is unseaworthy?
Indeed, Your Lordships. If the court manager could share the compendium, the page number 9.2. In the timing, I'll explain. Your Lordships, before the commencement of any voyage, the vessel undergoes a maneuverability test. Now, Lordships, this maneuverability test to ensure safe navigation under worst case scenarios. The rudder is always tested from 35 degrees starboard to 30 degrees port and the other way. Starting from straight motion at a test speed, the rudder is turned to 35 degrees or maximum rudder angle permissible and kept at this angle until the ship has performed a turning circle of at least 540 degrees. Lordship, this test is conducted for both the starboard side and the port side. This means that the enlisting of the vessel 35 degrees to the starboard presents no threatening situation in the present case. It is something for which the vessels are generally prepared for in the first place.
But is it not a decision or a call to be taken by the master of the vessel?
That
when
is
he's encountering adverse weather conditions.
Your Lordships, adverse weather conditions would be a common maritime peril, considering the fact that a vessel is trained to starboard and port 35 degrees based on these maneuverability tests, which means the enlisting of 35 degrees is no threatening situation in the present case.
So is it your argument that the decision taken by the master to declare general average was not proper, and it is on that count you say that the vessel was unseaworthy? Is that your argument?
Indeed, Your Lordships. It is because of the actionable fault of the master in the present case that made the vessel unseaworthy and he had to jettison such a huge amount of cargo.
So can such a thing be proved? Is it not something which has to be proved before the arbitrators in London? Because general average provides, York Anthrop rules provides for arbitration in London under the Lloyds.
Your Lordships, the same contention was forwarded by the council in the first issue, that had the vessel has been arrested in the present case, and it is humbly submitted that the present court be proceed with the arguments.
So the High Court is called upon to decide whether the jettisoning of cargo by the master was right or wrong.
The main issue is if the journal average is sustainable or not, which includes if jettisoning was right or not.
Yeah, then necessarily the court will have to go into that question, no, whether the jettison was right or wrong.
Indeed, Your Lordship, indeed.
So you expect the High Court to do that?
Indeed.
Under Admiralty jurisdiction.
Indeed, Your Lordships.
So you say that is something which can be done by the court?
Indeed, Your Lordship.
That's interesting.
Secondly, Your Lordships, it is humbly submitted that all ships today are fitted with marine forecasting equipments that measure the speed of air to forecast sudden changes. In addition to that weather bows move across the ocean, which check the situation on the sea, Your Lordship. Now, it is humbly submitted that the unseaworthiness in the present case was because of the actionable fault of the master. And unseaworthiness being the result of the owner's fault, emancipates the petitioners from the payment of general average security under the breach of Article 3, subclause 1, subclause A of the Hague-Wisby rules, and therefore the owner cargo had no obligation to contribute to the general average, as the losses and sacrifices were caused because of the master's so-called actionable fault.
How does Hague-Wisby rules apply to charter party?
Your Lordships, Hague-Wisby rules apply to every charter party in which bill of lading is issued, and the Hague-Wisby rules have been incorporated into the Indian law under the Cox Act.
No, that is true, but Hague-Wisby rules only apply to bills of lading.
Indeed, Your Lordship.
Yes, so your claim is under the charter party.
Your Lordships, the claim under the charter party is only of the jurisdiction of the present court and not of the general average. The general average is under the bill of lading.
Speaker 1, you may please conclude as your extra time is over.
Indeed. Hence, Your Lordships, having forwarded all the arguments, the speaker humbly concludes that it is the unseaworthiness was the direct cause of present predicament. Hence, the because of the owner's actionable fault, emancipates the petitioners from the payment of general average security. Hence, the owner's demand for general average security is not legally sustainable in the present case. It was indeed an honor arguing before. I would request the speaker number 2 to continue with his arguments. Thank you.
The Lordships are ready. The Speaker 2 may start your presentation. Speaker 2 is allotted 23 minutes of time based on the time apportioned. May start now.
Am I audible, Your Lordships?
Yes.
Greetings, Your Lordships. This is the Council number 2 representing on behalf of the claimants, Octa Limited. The Council, Your Lordships, over the course of the next 23 minutes will be dealing with the issues in the order of first, issue number 4, then issue number 5, followed by issue number 3. With your permission, Your Lordships, the Council may begin with the issue number 4.
Go ahead.
Lordships, the issue number 4 states that since the claim for short delivery of cargo is raised before the court, where a counterclaim is also raised by the owners demanding GA contribution, whether the court can adjudicate on the rival claims considering the fact that the alleged damage occurred within its territorial waters. Lordships, the petitioners contend that the court should not adjudicate on the counterclaim filed before the court, and the council puts forth the following contentions in its favor. Lordships, the council would like to begin the issue by defining counterclaim as stated in the Code of Civil Procedure. Lordships, a counterclaim in Order 8, Rule 6A of Code of Civil Procedure 1908 is defined as a defendant by means of counterclaim can claim any form of a right or claim with respect to a cause of action that accrues to the defendant against the claim of the plaintiff. Lordships, in the case of Bow, McLachlan and Co., versus ship Camosun, which is referred to under the arguments advanced of the Moot Court Memorial on page number 12, point number 53. If your lordships could refer to the page number 12, point number 53. Shall I proceed, your lordships?
Yes.
In this case, the Supreme Court of Canada observed that a counterclaim is substantially a cross action and not merely a defense to the plaintiff's claim. Lordships, it is humbly submitted that the counterclaim raised by the defendants demanding general average contribution is merely a defense to the claim raised by the claimants of short delivery of cargo and is not an independent cross-action suit. Lordships, the short delivery of cargo was caused by the defendants when the ship was in peril during its journey, as it had listed by 35 degrees to the starboard side, which is the right side of the ship. As a result, your lordships, the master of the vessel decided to jettison some cargo, and the defendant, due to the loss of cargo, demanded general average contribution. Your lordships, it is important to note that in the facts of the present case, the owners of the ship did not release the cargo for the claimants on reaching their destination at the Mumbai port, stating that the claimants are bound to pay for the general average security. It is also mentioned in the facts of the case that the claimants had then paid the general average security to the owners of the ship through their cargo insurers. Lordships, the fact that the petitioners have already paid their part of the general average contribution immediately proves that the counterclaim raised by the respondents demanding general average contribution is invalid. Since the petitioners have already paid their contribution, paid their part, the counterclaim
You already paid the security.
Yes, your lordship.
Security is provided by the insurance company on your behalf.
Yes, your lordship.
There is no adjudication of that claim so far.
Indeed, your lordships. However, the general average security is what is due to the ship owners on behalf of the common adventure to ensure that all parties contribute equitably to losses that have been
So you say that that amount can be appropriated by the ship owner towards your contribution.
Indeed, your lordships.
Accepting that.
Your lordships, the general average security is basically same to the general average contribution, and the petitioners have already.
Security is one thing, contribution is another thing. Contribution is determined by the average adjusters. After going through the entire claim and deciding who is at fault and what is the extent of liability that the ship owner has, and how to appropriate the amount payable by each cargo interest. So that exercise has not happened here. So they have only asked you to provide security, which you provided. So are you agreeing with the claim of the ship owner for the general average?
Your lordships, the council has another argument in favor of their own contentions. If lordships give us the permission to continue with that argument. Your lordships, it is pertinent to note that since my worthy co-counsel in their arguments have proved that the vessel was unseaworthy and the demand for general average is unsustainable, lordships, the council humbly submits that because of the vessel being unseaworthy and the demand for general average not being legally sustainable, the counterclaim raised by the respondents before the court of demanding general average is also not sustainable. Therefore, your lordships, according to Rule 6C of Order 8 of Code of Civil Procedure, which is referred under the Moot Court Memorial on page number 11, point number 50, page number 11, point number 50, according to Rule 6C, the plaintiff can contend that the counterclaim raised by the defendant should be excluded and ought not to be disposed of by way of counterclaims. Therefore, according to this rule, your lordships, the petitioner contends that the court should not adjudicate on this counterclaim.
What are the grounds on which a claim for general average can be objected by the cargo interest?
Your lordships, if the vessel was unseaworthy, then the plaintiffs don't have to pay for the general average.
But that is a matter to be proved. Yes, of course, you're right. If it is unseaworthy, then that's a defense. But that is a matter to be proved in evidence.
Your lordships, my worthy co-counsel in their arguments have proved that the vessel was unseaworthy and the general average is unsustainable.
That is only your submission. Is it an admitted fact that the vessel is unseaworthy? No, it's only your argument.
Indeed, Your Lordships, it was an argument given by my worthy co-counsel that due to the actionable fault of the ship of the captain, the vessel was unseaworthy, and the general average, the demand for general average, is legally unsustainable.
See,
And
if there is an extraordinary sacrifice made by the master or the owner of the vessel, are they not entitled to claim general average as a matter of right?
Much obliged, Your Lordships. Your Lordships, in a maritime adventure, bad weather is not an extraordinary peril. It is a common peril. And Your Lordships, because as my worthy co-counsel had stated, the maneuverability test, according to which the ship is commonly listed to 35 degrees to the starboard side and to the port side. And in the present case, the master of the vessel decided to jettison the cargo when the ship had listed by 35 degrees. It proves that the vessel, the master of the vessel was not fit enough to pilot the ship, and therefore the vessel was unseaworthy, and the demand for general average is not legally sustainable.
So you mean to say that the captain should have taken the risk, even if there is adverse weather condition?
Your Lordships, according to the maneuverability test, the listing of 35 degrees is not a threat to the vessel. It's a common thing to be done. So the decision of the master of the vessel to jettison the cargo when the listing of the ship to 35 degrees is a common thing. It's not a danger to the vessel. The master of the vessel should not have decided to jettison the cargo. If Lordships have any preliminary queries, the council would like to move on to the fifth issue. Lordships, the fifth issue asks whether the provisions of the Arbitration Act would exclude an action in rem from its purview as non-arbitrable. Lordships, the petitioners contend that action in rem is excluded from the purview of Arbitration Act as non-arbitrable, and the council puts forth the following arguments in its favor. Your Lordships, the Arbitration and Conciliation Act 1996 does not define arbitrability. Neither does it specify any set of disputes to be non-arbitrable. Hence, Your Lordships, the law in this regard has developed largely through judicial pronouncements. Your Lordships, before the council delves deeper into the arguments, the council would like to explain what exactly an action rem is. Your Lordships, it is by an action rem that the arrest of a ship is secured by a plaintiff. For this purpose, the ship is treated as a person. The plaintiff does not sue the person directly and by name, but the owner and anyone interested in the proceedings may appear and defend. Your Lordships, in Booz, Allen and Hamilton versus SBI Home Finance Limited, Your Lordships, the council would refer the court officer to refer to the compendium on page number 29, paragraph 37. Page number 29 on the compendium.
Is there any judgment which says that an admiralty action in rem is not arbitrable?
Your Lordships, in the case of Vidya Dhrolia versus Durga Trading Corporation, a three-judge bench of the Supreme Court in 2021 was required to determine the arbitrability of landlord-tenant disputes.
Yes.
But the court had emphasized that when the cause of action is in rem, then the dispute would be non-arbitrable.
So and all in rem actions are excluded from the purview of arbitration? Is that your argument?
No, Your Lordships. Lordships, the council in the Booz, Allen and Hamilton versus SBI Home Finance Limited, the Honorable Supreme Court had explained action rem and action in personam as a right in rem is a right exercisable against the world at large, whereas the right in personam is one exercisable against specific individuals.
Yes.
Your Lordships, the court had concluded that traditionally all disputes relating to rights in personam are considered to be amenable to arbitration, and all disputes relating to rights in rem are required to be adjudicated by courts and public tribunals, being unsuited for private arbitration. However, Your Lordships, this is not a rigid or an inflexible rule. Disputes relating to subordinate rights in personam arising from rights in rem have always been considered to be arbitrable. Your Lordships, it is humbly submitted before the court that when the ship had reached the Mumbai port, the plaintiff had the ship arrested, which was an action in rem. Following that, Your Lordships, the plaintiff had filed a claim before the Honorable Court.
So what happens after the arrest of the vessel? The ship owner appears, right?
Yes, Your Lordships.
And he defends the claim. So
Indeed.
From that moment, will the nature of the proceedings change from in rem to in person?
Your Lordships, when the ship had been arrested and the security had been paid, following that, the plaintiff had filed a claim before the Honorable Court for the short delivery of cargo.
No, I'm not talking about your claim. We are asking, so once the ship owner appears in an action in rem, you say an admiralty action is an action in rem, which is correct. So once the ship owner appears, does it become an action in personam? Does it not become an action in personam? Because the ship owner appears and then he is conducting the case.
Indeed, Your Lordships, when the owner of the ship pays the security,
and then it becomes an action in personam. So where is the bar under the Arbitration Act? It is an action in personam.
Your Lordship, the petitioner contends that the plaintiff had filed a claim before the Honorable Court for the short delivery of cargo, which is again against a res specifically and not a person. Lordships, for the recovery of the loss of res, the plaintiff had then proceeded against the owners and anyone interested in MV Moonlight, the ship from which the cargo was lost.
Yeah.
Hence, Your Lordships, the present case does not fall under subordinate rights arising from rights in rem and is simply an action in rem.
So once an action in rem, suit is instituted as an action in rem, it continues as an action in rem till the end. Is that your argument?
No, Your Lordships. When the owners of the ship had bailed the ship out of arrest, the proceedings continue in action personam. However, the claim which was put forward by the plaintiff for the short delivery of cargo was against a res, and the plaintiff had not proceeded against a specific individual. The plaintiff had proceeded against a res, which was the short delivery of cargo, and had proceeded against the owners and anyone interested in MV Moonlight, from which the ship was from which the cargo was lost. Hence, Lordships, the action still falls under action in rem. Shall the council proceed?
Yes.
Your Lordships, there are also other instances where courts have rejected the plea for arbitration on the ground that the matters contained an action in rem. Lordships, in the case of Indian Performing Rights Society Limited versus Entertainment Network, which is referred under the arguments advanced on page number 14, point number 64. If Lordships could refer to page number 14, point number 64. The third line, the Bombay High Court had stated that a party, even by consent, cannot confer jurisdiction on the arbitral tribunal in case of an action in rem. Hence, Your Lordships, since the Arbitration Act does not specify any set of disputes as non-arbitrable, and the law in this regard has developed largely through judicial pronouncements, and according to the case laws mentioned, action in rem is stated as non-arbitrable, and in the present case, does not come under the special case of subordinate rights arising from rights in rem. Therefore, it is humbly submitted before the court that an action in rem is excluded from the Arbitration Act as non-arbitrable. If Your Lordships are satisfied with the contention, then the council would like to move on to the third issue.
Yes.
Much obliged, Your Lordships. Your Lordships, the third issue asks whether the court is bound by sanctions imposed by a third country. Your Lordships, the petitioner contends that the court is not bound by the sanctions imposed by a third country, and the council puts forth the following arguments in its favor. Lordships, the council would like to begin the issue by explaining the sanctions, in this case, the SDN list sanctions imposed by the United States of America. Lordships, the Office of Foreign Assets Control, or OFAC, is a US Treasury Department agency, which administers and enforces economic and commercial trade sanctions against states, organizations, and individuals. Lordships, these sanctions are based on the US foreign policy and national security objectives, and are imposed on them who violate such policies. Lordships, the entities on whom these sanctions are imposed are described by OFAC as specially designated nationals and are included in the SDN list. Lordships, the consequence of being sanctioned is that all US persons are prohibited to make any transactions with such entities included on the STN list. Not only that, but even non-US persons who are beyond the territorial jurisdiction of the United States are also prohibited from transacting with entities mentioned in the STN list. This prohibition on non-US persons is known as secondary sanctions. Lordships, these secondary sanctions are very controversial in nature, since it requires a country to apply its laws extraterritorially to persons beyond their territorial jurisdiction. Lordships, the consequence of violating such sanctions is that the violator is blocked or cut off from accessing the US dollar denominated financial markets and may even be placed on the STN list. Lordships, it is important to note that the petitioners contend that the court will not be bound by the sanctions imposed by a third country. Lordships, the reason for that is that according to the proposition, the petitioner paid for the general average security to the respondent through their insurance company, which is present in the STN list. And the petitioner also settled the cargo claim with the insurer present in the STN list. Hence, your lordships, the petitioner is in danger of getting sanctioned by the United States for transacting with an entity present in the STN list. However, your lordships, the petitioner contends that the extraterritorial jurisdiction applied by the United States to impose sanctions goes against customary international law and is therefore illegal. Are lordships with me?
Yes.
Lordship, much obliged, lordships. Your lordships, the US economic sanctions are opposed by most countries for this very reason, that is their extraterritorial reach, which is deemed to be a massive overreach in a world of equal nations. However, lordships, it is important to note that under customary international law, states are still allowed to justify their extraterritorial jurisdiction under a few principles. And also, lordships, the United States treats customary international law rules as rules of federal law and thus are binding. Lordships, there is a principle called protective principle, which allows states to apply their jurisdiction in a foreign state for a crime that threatens the security of the former state. Lordships, in the present case, the petitioner paying the general average security to the respondent through insurance from a company included in the STN list does not threaten the security of the United States in any way. Similarly, lordships, the petitioners had settled the loss of cargo through insurance, which also does not threaten the security of the United States. Lordships, the petitioner is simply making payments. Lordships, hence the protective principle cannot be applicable here. Another principle, your lordships, is effects doctrine, which comes under the territorial principle. The territorial principle states that each nation possesses an exclusive jurisdiction within its own territory. Your lordships, the effects doctrine regards conduct that, even though carried out abroad, produces a direct, substantial, and foreseeable effect in the state asserting jurisdiction. Lordships, now in the present case, the petitioner company Octa Limited, paying general average security through the insurance company present in the STN list or settling cargo claim with the insurer, which is present in the STN list, does not cause any direct or substantial effect, less a harmful one, within the territory of the United States in any way. Hence, your lordships, the effects doctrine is also not applicable. Since, your lordships, all the principles which could possibly justify the use of extraterritorial jurisdiction by the United States are not applicable here. Hence, the secondary sanctions are not only against customary international law, but also do not have any means to be applicable on foreign countries. Now, your lordships, the Permanent Court of International Justice in 1927, in the case of France versus Turkey, which is referred under the Moot Court Memorial under the arguments advanced on page number 9, point number 38. If your lordships could refer to page number 9, point number 38, the Permanent Court of International Justice stated that the first and foremost restriction imposed by international law upon a state is that it may not exercise its power in any form in the territory of another state. Lordships, regarding foreign policies, are lordships with me?
Yes.
Are lordships with me?
Yes, yes.
Yes.
Much obliged, lordships. Regarding foreign policies, the International Court of Justice in the case of Nicaragua versus United States, which is referred under the arguments advanced on page number 9, point number 40, if your lordships could refer to page number 9, point number 40, stated that the formulation of foreign policy is a matter in which each state is permitted by the principle of state sovereignty to decide freely. Since, your lordships, the United States forces other countries and individuals to cooperate with its sanctions, which are based on its country's own foreign policy, which in turn forces other countries to abandon their country's foreign policy and follow along with the United States of America. This, Your Lordship, goes against the judgment of the International Court of Justice. Hence, Your Lordships, since all the principles of jurisdiction that could have justified the use of extraterritorial jurisdiction by the United States of America is not applicable in the present case, and according to the judgments of the Permanent Court of International Justice, no state may exercise its power in the territory of another state. It is humbly submitted before the court that the court would not be bound by the sanctions imposed by a third country. Are Your Lordships satisfied with the contention?
Yes.
Your Lordships, then the council would like to move on to the prayer.
Yes.
Much obliged, Your Lordships. It is most humbly prayed before the Honorable Court of Mumbai that in the light of facts mentioned, arguments advanced, and authorities cited, the Honorable Court may be pleased to adjudicate and declare that the Admiralty jurisdiction of the court is valid, the declaration of general average is not legally sustainable, the court is not bound by the sanctions imposed by a third country, the court cannot adjudicate on the counterclaim raised by the respondents, the provisions of Arbitration Act excludes an action in rem as non-arbitrable, and any other relief that the Honorable Court may be pleased to grant in the interest of justice, equity, and good conscience. It was an honor arguing before the court, Your Lordships.
Yes, court officer, why don't we start the
Yes, Your Lordship.
respondents?
If Your Lordships are ready, I would like to invite the first speaker for the petitioner to speak. Speaker 1 of IMC 113. Your time starts now.
Greetings to the bench. The council seeks permission to commence the pleading.
Go ahead.
Much obliged, Your Lordship. If it may please this honorable court, the council is appearing on behalf of the defendant in the matter of Octa Limited versus owners and parties involved in Moonlight. The council would be addressing the first and second issue and would be taking 22 minutes of the court's precious time, whereas the co-counsel will also be taking 22 minutes of the court's precious time, and we most respectfully reserve 1 minute for rebuttal. If the lordships are well versed with the facts of the case, the council would like to proceed with the arguments.
Continue your way. Don't wait for permission. Go ahead.
Indeed, Your Lordship. To begin with, our first issue is the exercise of admiralty jurisdiction by the courts is not valid in view of the arbitration clause in the Charter Party. It is humbly submitted before this honorable court that the exercise of admiralty jurisdiction by the court with view to the arbitration clause in the Charter Party is not valid because the Charter Party terms will define the jurisdiction of disputes between the parties. Your Lordship, in the instant case, claimant is the charterer of the vessel named Moonlight, a seagoing vessel flying the flag of Indo. A clean fixture was confirmed between the ship owner, that is Moonlight, and the charterer, that is Octa Limited, for the vessel. The parties agreed on the seat of arbitration for resolving problems related to the maritime adventure that the dispute should be decided in London. Your Lordships, if you could refer to page 4, first line of the Moot proposition. Are you with me, Your Lordships?
Yes.
A loss of cargo is also covered under the Charter Party, according to you. Loss of cargo
Your Lordship.
is also covered under one of the disputes under the Charter Party.
Yes, Your Lordship.
Which provision of the New York Produce Exchange form says that?
Your Lordship, all disputes come under.
No, that is generally, you say all disputes arising under the Charter Party can be referred for arbitration in London. That is for general. Now here they are very specific that, they have lost 650 metric tons of cargo. So which is essentially a cargo claim. So which part of the NYP form which you have used for the, the Charter Party says that if there is a cargo loss, that is something which can be arbitrated.
Indeed, Your Lordship. Your Lordship, it is clearly stated in the Moot proposition that the charter party is an NYPE form. It was clearly stated in the Moot proposition that the charter party terms, among other things, provides for arbitration in London for resolving all disputes between the claimants, charterers, and owners. Your Lordship, if we, in the case of Reliance versus Union of India, the court focused on the intention of the parties. In the instant case, the seat in London is already mentioned, which means that their rules will be applicable. Once the seat of arbitration has been decided to be a particular country, it is de facto implied by that conduct that the rules, regulations, and laws of that country will be applicable, notwithstanding any agreement to the contrary. In the instant case, also, Your Lordship, in the charter party, the parties have already agreed that all disputes related to the maritime adventure shall be settled in London, thus vitiating the Indian courts of any jurisdiction over the matter. Your Lordship, there can be only two situations under which this.
Madam, one question. Would your raising of a counter claim mean that you have submitted to the jurisdiction of this court? Why would you raise a counter claim otherwise?
Your Lordship, the petitioners have approached the High Court. Approached this High Court while the respondents are contending that the reaching to this court for jurisdiction is not valid.
Now, correct. But if you have raised a counter claim, when is a counter claim raised? Counter claim is generally raised before a court having jurisdiction.
Indeed, Your Lordship.
You are also treated to be a plaintiff for some purposes, plaintiff or petitioner or whichever way you want to call it, because you are raising a claim, separate individual claim.
Indeed, Your Lordship.
Now, does your act of raising a counter claim show that you are submitting to the jurisdiction of this court or waiving your objection to the jurisdiction of this court?
Indeed, Your Lordship. Your Lordship.
And secondly, can jurisdiction be conferred by consent of two parties? Suppose both of you agree that the Indian court, this court has got jurisdiction. If it is otherwise not there, does it confer jurisdiction on this court? Both of you agree, there is no objection by either side. Does that confer jurisdiction?
Your Lordship, it was a mutually decided agreement. The council would be dealing with this issue in greater length, but for the Lordship's instant query, the council would like to submit that, Your Lordship, under Section 45 of the Arbitration Act, according to this act, it mandates a court to refer the parties to arbitration when the dispute is subject matter of a valid arbitration clause having a foreign seat of arbitration. Your Lordship, in the instant case, the parties have agreed on the seat of arbitration for resolving problems connected to the maritime adventure, that the dispute should be decided in London. Your Lordship, now, Section 45.
Where did this happen? Where did this? I mean, it happened in Indian territorial waters. This act of the captain in dumping the cargo, did it happen in Indian territorial waters? It happened in Indian territorial waters.
Indeed, Your Lordship.
So what? How do you deal with the principle of forum non-convenience?
Indeed, Your Lordship. Your Lordship, the counsel for the petitioners did not invoke Section 9 of the Arbitration Act, which deals with interim relief. The claimants don't want this as an interim relief. They are trying to run a parallel proceeding, which clearly shows their malified intention on their part. They want arbitration as well as proceedings. They can use any proceeding to their advantage. If they wanted interim relief, they should have come under Section 9. This clearly suggests that they wanted this court to see the case in merits. Your Lordship, post 2015 amendment, Section 9 of the Arbitration Act applied to foreign ceded arbitration. Section 9 is the power of the court to interim relief in arbitration. Post 2015, that was extended to even foreign ceded arbitration. Your Lordship, Section 9 does apply, but today the court is not exercising a Section 9 power. They did not file a Section 9 application The court today is assuming jurisdiction of 4F. Your
No,
Lordship,
sir.
arrest.
Coming back to the question of forum non-convenience, you didn't answer that. I mean, suppose the best evidence is available within the jurisdiction of this court. Would that not be a factor in deciding that this matter should proceed here rather than going to arbitration in London? Because the issue happened in Indian territorial waters. What was the weather condition? What prompted the? All these are matters of evidence, which is easily available in the country rather than before an arbitral forum in London. Would that not be a issue to be decided? Suppose we decide that the best evidence is available in this country or within the jurisdiction of this court.
Your Lordship, the facts of the case are silent upon where the jettisoning of the cargo happened.
Yes.
Should the council proceed with the argument, Your Lordship?
Yes.
And your argument based on Section 9, which provision of law under the Arbitration Act says that as an interim measure, the arbitrator can grant an order of arrest of a vessel?
Your Lordship, can you repeat your question?
See, under Section 9 of the Arbitration Act, you said interim release can be granted by the arbitrator, which is correct, right? Now, can the arbitrator under Section 9 grant an order of arrest of the vessel? Who can order an arrest of the vessel? It is only by an admiralty
No,
court,
Your
no,
Lordship,
exercise of admiralty
since-
jurisdiction. Does the arbitrator have admiralty jurisdiction?
No, Your Lordship, since arrest of vessel is right in rem, and right in rem is non-arbitrable, so it can't be proceeded towards arbitration. Your
No, you
Lordship,
were saying that they should have applied under Section 9 of the Arbitration Act, right?
indeed, Your Lordship. Your Lordship,
Yeah.
Section 9 is maintainable. But in the instant case, the counsel for the petitioners did not invoke Section 9, they invoked Section 4F of the.
Now, how can they invoke Section 9 of the Arbitration Act? Because arbitrator does not have a power to arrest a vessel, which can be granted only by a court having
Indeed,
admiralty
Your Lordship.
jurisdiction.
Indeed, Your Lordship. Your Lordship, if the counsel for the petitioners wanted this court to exercise their powers in order to make the vessel arrested, they should have come under Section 9. But they did come under Section 4F.
No, how is it possible? That's what I'm asking.
Counsel,
Section 9.
question is this: could they have asked for an injunction instead of an arrest under Section 9? Essentially preventing what is an arrest of a vessel? It is essentially preventing the ship from going outside jurisdiction, so that there is security for a claim to be raised later in other proceedings or the same proceeding or whatever it is. Now, would an injunction also suffice? Suppose the court were to, the arbitrator or the court under Section 9 were asked to pass an order of injunction restraining the captain of the vessel from sailing the vessel or preventing the port in which the vessel is docked to permit the vessel to leave from there. Would that also not suffice? Is that your argument?
Your Lordship, the counsel for respondents wants the dispute to be referred for arbitration. Your Lordship, the claimants cannot exercise their right in rem action, since under Section 45, both the in rem admiralty suit based on a maritime claim and the claim in an arbitration seated outside India arise from the same cause of action. Since the subject matter of both these proceedings would be the same, admiralty suit would be barred in view of the plain language of Section 45 of the Arbitration Act, which mandates that the court shall refer the parties to arbitration when the dispute is subject matter of an arbitration clause with foreign seat. Your Lordship, these are parallel proceedings. These are proceedings arising out of same cause of action. If today we start looking on merits, arbitration tribunal in London will also start looking on merits. These parallel proceedings are not allowed. In such a case, one has to stop. Your Lordship, since both parties agreed for arbitration at London according to the Moot proposition, so now, Your Lordship, according to Section 45, the judicial authority shall refer parties to arbitration. Your Lordship, the Admiralty law in India, prior to the Admiralty law, prior to the Admiralty Act was the International Convention on Arrest of Ships 1999. Article 2, subclause 3 of the said convention, Your Lordship, specifically provided for a situation where an action in rem is maintainable even during pendency of an arbitration seated outside India. However, Admiralty Act has excluded a provision analogous to Article 7 of the said convention by not having a specific provision empowering the courts to arrest vessels during pendency of an arbitration seated outside India. Hence, impliedly, the Admiralty Act itself does not contemplate such a rem action. The Lordship, the intent of the Parliament makers was to not have these parallel proceedings in rem and in personam.
It is not parallel proceedings because see, like how the claimants are put it, they are proceeding against the rem, which is a vessel alone. They are not proceeding against the owners. Are they not justified in seeking an arrest of the vessel and maybe obtain a security?
Your Lordship, Your Lordship, the arrest of the vessel can be done by this court exercising Section 9 of the Arbitration Act. We cannot assume jurisdiction by Section 4F and 5. Indian courts will, Your Lordship, the counsel for the respondents totally agree that the Indian courts will only have the power to arrest the vessel, but they will do this under Section 9. Section 9
we can't agree with you. Under Section 9, there is no arrest. There can be no arrest.
Your Lordship, the counsel for the respondent submits that interim measure can be provided to the claimants.
No, interim relief can be granted. See, Admiralty Act is a special statute, right? It is only under the Admiralty Act, provision is made for arrest of a vessel. There is no other provision or any other statute which deals with arrest of things. It is only there under the Admiralty Act. So how can we bring Admiralty Act into the Arbitration Act? If you are saying that under Section 9, the court can grant order of arrest under Section 9 as an interim relief, how is it possible? When arrest is possible only under the Admiralty Act.
Indeed,
But the question is this. My learned brother has asked you this question. See, vis-a-vis the Arbitration Act, is the Admiralty Act a special law which overrides the general law? What is the maxim that applies? What is the maxim? You heard of the maxim which says a special law will override a general law?
Indeed, Your Lordship.
What is the maxim? Generalia specialibus non derogate. So what happens? Suppose we treat the Arbitration Act to be a general law and the Admiralty Act to be a special law. Can we not say that apart from the fact that it is an action in rem, would we not be also entitled to say that whatever be the remedy available under the Arbitration Act, for interim relief under Section 9, when a special law takes care of, maritime claims, the petitioners would be entitled to apply under that law, notwithstanding any provision in the general law. This is the question that my brother has put to you.
Indeed, Your Lordship. Your Lordship, in the case of Bharat Aluminium Company versus Kesar Aluminium Technical Services, the court entirely held that as a matter of law, an inter-parties suit simply for interim relief pending arbitration seated outside India, even if it be limited for the purpose of restraining dissipation of assets, would not be maintainable. It was further held in the same case that pendency of arbitration proceedings seated outside India would not provide a cause of action for a suit where the main prayer is for injunction, and it would not be open to a party to file a suit touching on the merits of the arbitration. If such a suit were to be filed, it would in all probabilities be stayed in view of the Section 45 of the Arbitration Act.
Was that case dealing with arrest of vessel? I don't think. That's a different case.
Your Lordship, could you come again?
the decision that you referred, that was not a case dealing with arrest of a vessel, right?
Your Lordship, Your Lordship, in the Bharat Aluminium Company versus Kesa Aluminium Technical Services did talk about the interim measures. There wasn't any arrest of the ship. The council totally agrees to that.
Yes.
Yes.
Your Lordship, should the council proceed?
Yes.
Go ahead.
Your Lordship, Section 4 and 5 of the Admiralty Jurisdiction of Maritime Claims Act 2017 would not apply to foreign ceded arbitration. These will only apply to Indian ceded arbitration. If Sections 4 and 5 start applying, this would disturb the principle of party autonomy. Your Lordship's party autonomy is the brooding and guiding spirit of arbitration. Your Lordship, what will be the point of foreign ceded arbitration if Indian courts are intended to rule on merits? Your Lordship, Section 5 cannot be applied as interim relief on a foreign ceded arbitration as held in the case of Balco, that an inter-party suit simply for interim relief pending arbitration ceded outside India, even if it be limited for the purpose of restraining disappreciation of assets, would not be maintainable. Your Lordship, the consequence of an arbitration agreement is that it bars both the parties from approaching the courts for adjudication of the disputes. Both the REM Admiralty suit based on a maritime claim and the claim in an arbitration ceded outside India arise from the same cause of action. Since the subject matter of both these proceedings would be the same, Admiralty suit would be barred in view of the plain language of Section 45 of the Arbitration Act, which mandates that a court shall refer the parties to arbitration when the dispute is the subject matter of an arbitration clause with foreign sea. Consequently,
did you hear the other side arguing with reference to a judgment? I forget the name of the judgment, where they said that the court should look at the intention of the parties. Can you say on the facts of this case that when the charter party agreement was made and the arbitration clause was incorporated, the parties had contemplated a claim relating to loss of cargo?
Your Lordship, could you come again?
Intention of the parties is important in interpreting. They relied on a judgment, which is the judgment counsel for the petitioner, who were referred to that judgment.
Which judgment, Your Lordship? Or
Said something about intention of parties being important in interpreting the arbitration clause also. Some judgment was cited.
Your Lordship's no judgment on intention was cited by petitioners.
All right.
Your
Now,
Lordship.
coming back to the question, forget the judgment. Was the loss of cargo an issue contemplated by the parties at the time when the charter party was made?
Your Lordship, could the council answer to your previous question first?
Yes.
Your Lordship, you did talk about the intention of the parties. Your Lordship, the counsel for the respondents submitted that in the case of Reliance versus Union of India, the court focused on the intention of the parties. And Your Lordship, in the instant case also, the seat in London is already mentioned, which means that their rules will be applicable.
Correct. It's all right. Now, anything relating to the charter party, the intention of the parties is to, adjudicate it by arbitration in London. No problem regarding that. Question is, did the parties contemplate at the time when they made the charter party that there would be a claim relating to loss of cargo between the parties, which would also have to be referred to arbitration in London? Or was it just the arbitration clause only covered the terms of the charter party?
Your Lordship, in the Moot proposition, it's clearly mentioned that it mentioned that all disputes related to loss of cargo all would be settled through arbitration at Lloyd's London.
All disputes relating to what? That's the point. You are right. All disputes relating to what? Relating to the charter party.
Your Lordship.
Now, did it also contemplate all disputes? Those words, all disputes, did it contemplate a loss of cargo as well? That's the question that is to be answered.
Indeed, Your Lordship, as it talks about all the disputes between the charterers and the ship owners.
You say that all disputes is wide enough to cover claims relating to cargo as well, loss of cargo as well.
Under arbitration, indeed, Your Lordship. Indeed, Your
Yes,
Lordship.
yes.
What if they say that their claim is confined to the the issue under the bills of lading? Bills of lading does not provide for an arbitration.
Indeed, Your
Suppose-
Lordship.
Yeah, suppose they say that their claim is only under the bill of lading.
Your Lordship. Your Lordship, a clean fixture was stipulated between the charterers and the ship owners, which clearly suggests that both the parties confirmed.
Forget
that
about the charter party. Forget about the charter party. Do you admit that you have issued a bills of lading? On receiving cargoes, you have issued a bills of lading, right?
Your Lordship.
Now, when you discharge the cargo, they found that there is short delivery.
Indeed,
So
Your Lordship.
that can give rise to a claim for shortage of cargo, correct?
Indeed,
It
Your
need
Lordship.
not be under the charter party, but it can be very well under the bills of lading.
Indeed, Your Lordship.
Suppose the Admiralty suit is filed for claiming shortage of cargo, claiming damage for shortage of cargo. They say that it is only under the bills of lading and not under the charter party. So where is the question of arbitration arising under that? Or under what circumstance do you say that under the charter party, they have to arbitrate the entire issues in London?
Indeed, Your Lordship.
There is one circumstance I want you to tell that.
Indeed, Your Lordship. Your Lordship, as it
You answer that question by saying that when parties are the same, parties to the charter party are the same, A and B, yourself and the claimant. And it so happens that the parties to the bill of lading are also the same. Is it your contention that in such an event, the arbitration clause covers issues under the bills of lading also?
indeed, Your Lordship.
Yes. Go ahead. You can continue.
All right. Your Lordship, the council seeks an extension of 5 minutes to quickly wrap up the second issue in hand.
Go ahead.
Yeah, Your Lordship, the council seeks 30 seconds to just wrap up the first issue first. Then the council will proceed to the second issue.
Yes.
Much obliged, Your Lordship. Your Lordship, since in the first issue, the counsels for the petitioners did not invoke Section 9 of the Arbitration Act, which deals with the interim measures. The claimants did not want this. They did not want the arrest of the vessel as an interim relief. They were just trying to run a parallel proceeding, which clearly showed their malified intention on their part. They wanted arbitration as well as parallel proceedings. They can use any proceeding to their advantage. If they wanted interim relief, they should have come under Section 9. This clearly suggests that they wanted the court to see the case in merits. Your Lordship, Section 9 is totally maintainable with respect to the interim measures, with respect to arresting the vessels. Your Lordship, Section 9 of the Arbitration Act applies to foreign civil arbitration. Section 9 is the power of the court to grant interim relief in arbitration. Post 2015, that was extended to even foreign civil arbitrations. And yes, Your Lordship, it does apply. But today, the court is not exercising a Section 9 power. They did not file it under Section 9 application. The court today is assuming jurisdiction of Section 4F. Therefore, Section 5 cannot be applied. Hence, the council would like to conclude that the exercise of admiralty jurisdiction by the court is not valid in view of the arbitration clause of the charter party. Your Lordship, the council would seek permission to proceed with the second issue in hand.
Yes.
Much obliged, Your Lordship. Your Lordship, the second issue being the declaration of general average is legally sustainable. In this regard, the argument will be twofold. Your Lordship, in the instant case, Claimant is the charter of the vessel named Moonlight, a seagoing vessel flying the flag of Indo. Your Lordship, a clean fixture was stipulated between the ship owner and Octa Limited for the vessel. The charter party and clean fixture provided that the vessel should only travel between safe ports and not enter war zones. Your Lordship, according to Rule A of the York-Antwerp Rule, it clearly states that when and only when any extraordinary sacrifice or expenditure is intentionally and reasonably done or incurred for the aim of safeguarding the property involved in a common maritime adventure from peril, there is a General Average Act. The intent requirement is that the General Average Act must be made or incurred only for the purpose of protecting the interest at stake from peril. Your Lordship, in the instant case, the essentials of Rule A of York-Antwerp rules are fulfilled. In the instant case, there was an extraordinary sacrifice, that is the cargo loss, which was made reasonably for the common safety in order to save the remaining cargo for the purpose of preserving from peril the property involved in the common adventure. Your Lordship, there was an express promise of due care to this effect, which imposed an obligation on the master to take all reasonable measures to preserve the goods from damage. Therefore, jettisoning of the cargo was made in good faith. Now, moving on to the second limb of the counsel's argument, Your Lordship, if you could refer to page 4, second line of the Moot proposition. Are you with me, Your Lordship?
Yes, yes.
Your Lordship, it's clearly stated over here that the charter party was entered in NYPE form. Now, Your Lordship, according to clause 33, subclause C of the NYPE form, this talks about the new Jason rule. Your Lordship, according to this rule, the goods shippers, consignees, or owners of the goods shall contribute with the carrier in general average to the payment of any sacrifices, losses, or expenses of a general average nature that occur before or after the commencement of the voyage, resulting from any cause whatsoever, whether due to negligence or not, for which or for the consequences of which the carrier is not responsible. By statute, contract, or otherwise, the goods shippers, consignees, or owners of the goods shall contribute with the carrier. Your Lordship, a ship owner is under an obligation to practice due diligence at 2 times during a voyage. Firstly, before and after the commencement of the voyage, and secondly, during the voyage. Your Lordship, according to clause 33, subclause C of the NYPE, if any negligence is practiced during the time of the voyage, the claimants are still liable to contribute towards the general average. Here, due diligence to make the vessel seaworthy with respect to due diligence is only concerned with before or after the commencement of the voyage. This negligence was made during the voyage. Your Lordship, this is an exception under New Jason clause. Your Lordship, bad weather is an unforeseen circumstance. It cannot be corrected or curated by the general average. Your Lordship, the counsel for the respondents would like to submit that there is absolutely no evidence or record. Claimants have...
The permission of the Lordship, let me remind the speaker that your extra time granted by the court is over. You may please conclude now.
Your Lordship, the counsel would just seek 2 minutes for to quickly wrap up this argument.
Go ahead.
Much obliged, Your Lordship. Your Lordship, there is no evidence that proves that the vessel was unseaworthy or they did not exercise due diligence before or after the commencement of voyage. They did not know the density of the bad weather conditions. It was not like that it was raining and the vessel listed toward the starboard side. It was a bad weather. It could be heavy thunderstorm and it could be very harsh. And in such situations, even well-built ships could list. Your Lordship's Octa Limited, the claimant in this case, is both the owner of the goods and consignee on the vessel's bill of lading. Your Lordship, after the voyage commenced, the cargo was damaged. Even if the cargo was damaged by the vessel due to the vessel's unseaworthiness as a consequence of ship owner's negligence, during the course of the voyage, the claimant is still liable to contribute to GA according to the new Jason rule of NYPE. Your Lordship, based on the principle of reasonable care, the owner of a vessel has total discretion to determine which action to take in order to benefit the common adventure. The master's discretion is put to test as he is forced to make decisions in the presence of risk for the ship and the people on board in order to keep the adventure going. Your Lordship, the law of general average is an equitable doctrine that maintains that certain joint venture partners should not benefit from the misfortune of others. The master of a vessel confronting a storm may decide that some cargo must be jettisoned to lighten the vessel, thereby giving her a better chance to avoid sinking. For an act of general average to arise, the master's authority in cases of necessity, where he must act in the best interest of all parties, has never been questioned, and it was held by the House of Lords in Morrison versus Dresden Castle case. Your Lordships, in the case of State of Karnataka versus MS Krypton Ceramic Center, it was clearly held that bad weather was considered as a circumstance beyond one's control. It was caused due to unforeseeable
Madam,
events.
you have exceeded your 2 minutes. I think, court officer, your 2 minutes. That
Your
the case
Lordship,
is over.
the council just needs 30 seconds, Your Lordship. I'll conclude
Yes.
it. Yes, thank you. Much obliged, Your Lordship. In the instant case, jettisoning of the cargo took place due to bad weather and not because the vessel was unseaworthy. The bad weather was beyond the ship owner's control. It was an unforeseeable event. Moreover, due to the bad weather, the master of the vessel jettisoned around 650 metric ton of methanol in good faith for common good. Master of the vessel is the person to apply his reasoning and discretionary skills to at the time of danger. Your Lordship, if your Lordship,
Just one short question. Is not your claim for general average covered by the arbitration clause?
Indeed, Your Lordship.
Why did you raise your counterclaim here?
Your Lordship, the co-counsel of we will be dealing with counterclaims in the fourth issue.
All right.
If your Lordships don't have any further questions, the council would like to seek permission to invite the co-counsel to address third, fourth, and fifth issue.
Okay.
Much obliged, Your Lordship. Your Lordships, it was an honor to plead before this court.
Greetings.
Now start with your presentation. You have 22 minutes based on the portion of time.
If it may please this honorable court, the present council would like to begin. Much obliged, Your Lordships. Your Lordships, the council will deal with issue 3, 4, and 5. Now, beginning with the third issue that is present before this court, whether the court is bound by sanctions imposed by a third country. Your Lordships, the claimants Octa Limited insured their cargo from a notorious insurance company. This insurance company also obtained a letter of subrogation from the claimants. Now, interestingly, the said insurance company has been enlisted under the specially designated nationals list. That is the SDN list. Your Lordships, the SDN list is issued by Enforcement Agency of the US, Office of Financial Assets Control. Now, OFAC, as part of its enforcement efforts, issues list of individuals, groups, and entities such as terrorists and narcotics traffickers designated under programs that are not country specific. The assets of such entities are blocked by US, and US persons are generally prohibited from dealing with them. Your Lordships, SDN list constitutes as a secondary sanctions. Now, the secondary sanctions imposed by a third country are extraterritorial application of domestic laws with no jurisdictional link. However, it is pertinent that this court considers the intent of the sanctioning state behind enlisting the claimant's insurance company under SDN list. Your Lordships, you see, SDN lists are not just economic sanctions which serve to further United States foreign policy objectives. We are here looking at terrorists and international narcotic traffickers. And if this wasn't enough, SDN list has entities engaged in activities related to the proliferation of weapons of mass destruction. Your Lordships, these entities under SDN list not just pose a threat to the national security of the US, but to the international community at large. Thus, it would be a prejudiced take against the executive intent of the Office of Financial Assets and Control for this honorable court to completely disregard these extraterritorial sanctions. Further, Your Lordships, Currently, India does not have a dedicated policy mechanism to comply with extraterritorial sanctions. However, India's procedural laws create a presumption that foreign judgments are issued by a competent authority and are thus considered enforceable unless proven otherwise.
Do you have any judgment to show that US secondary sanctions are recognized by courts in India?
Your Lordship, the Council understands your concern. However, by virtue of Section 13 and Section 14 of CPC, the procedural laws of they create a presumption that foreign judgments are issued. However, by a competent authority, and to undermine the SDL list would be if this honorable court undermines the issuance of SDL list, then it would mean that the court is willfully enabling crimes against willfully enabling the crimes against the crimes that the insurance company is engaged into. Your Lordships, you see, it is evident that the SDL list, under this SDL list, entities are engaged in activities like narcotic trafficking, and there are entities which are enlisted as terrorists, which poses a threat against the international community. If that answers your Lordship's question.
Is there any international convention dealing with that, which says that a country which is issuing sanctions, other countries are bound to follow that? Is there any such convention, to your knowledge?
Your Lordship, to answer your Lordship's question, only UNSC resolutions are can enforce such sanctions. However, having said that, your Lordship, it is imperative that these extraterritorial secondary sanctions are scrutinized by territorial jurisdictions. Your Lordship, this is what the Council is trying to contend, that they should be tailored to regulate these extraterritorial sanctions should be tailored to regulate on a terinational level, that is combined basis of territorial and natural jurisdiction, the national jurisdiction. And to counter these adverse effects of secondary sanctions, the state can also make use of various non-judicial mechanisms, and such as blocking statutes. There exist EU blocking statutes to circumvent the reach of such sanctions. To answer your Lordship's question, currently India does not have a dedicated legislation and policy mechanism. But the Council humbly submits that the court, while considering this issue, has to consider that imposition of such secondary sanctions by a third country would be necessary and required to fulfill a legitimate international interest, and not merely imposing a foreign rule mandatorily. If your Lordships do not have any questions, no further questions, the Council would like to proceed to issue 4.
Yes.
Much obliged, your Lordships. Your Lordship, the 4th issue at hand asks that since the claim for short delivery of cargo is raised before a court, where a counterclaim is also raised by the owners demanding GA contribution, whether the court can adjudicate on the rival claims, considering the fact that the alleged damage occurred within its territorial waters. Your Lordships, let us first understand that the claim of short delivery of cargo is the original claim here, raised by the claimants Octa Limited, against which a counterclaim has been raised by the owners of MV Moonlight demanding GA contribution. Before moving to the arguments, the Council on behalf of respondent wants to clarify that the principal submission of the respondents remain that this court does not have jurisdiction either to hear a claim or a counterclaim, because that should be referred to arbitration, as has been already established by the co-counsel. However, Lordships, if this court assumes jurisdiction and moves ahead to hear the claims of claimants, then the respondents are also entitled to argue their counterclaim.
Then instead of filing a counterclaim, you should have filed an application under Section 8. to refer the dispute to arbitration.
Your Lordship, the Council understands your concern. However, Section 8 under Arbitration Act limits the judicial intervention, wherein there is a arbitration clause, wherein there is an arbitration agreement, and especially after the 2015 ordinance, there has been a limitation on the extent to which judiciary can intervene, where an arbitration agreement exists. Your Lordship, now the Council will deal with the issue that whether the court can adjudicate on the counter claim of GA contribution. Now to answer this question, the claimants have argued that the respondents should file an independent suit for their counterclaim. Your Lordships, under Civil Procedure Code, Order 8, Clause 6A, which reads about counterclaims, and I would like to quote here for the benefit of this honorable court, that a defendant in a suit may set up by way of a counterclaim against the claim of the plaintiff any right or claim in respect of a cause of action accruing to the defendant against the plaintiff either before or after filing of the suit, but before the defendant has delivered his defense or before the time limited for delivering his defense has expired. Your Lordships, now in the instant case, here the cause of action is loss of cargo, which gives rise to the event of GA contribution. And the respondent's counterclaim can only be excluded if there's an independent claim. Your Lordship, here we have to understand that the claim to the claim of cargo loss and the cause of action here for the claim is same. Loss of cargo, that is a loss of cargo. The cause of action here is the loss of cargo. Now, with the same parties to contract, same transaction, if this court is assuming jurisdiction to adjudicate on the claims under 4F of the Admiralty Act, then this court must also refer to the counterclaim raised by the respondents under 4Q of the same section, subclause Q of the Admiralty Act 2017. Your Lordships, it is only logical for this court to treat the counterclaim of the respondents under the same suit. There is no need for an independent suit because, again, the cause of action for this claim is same, which is the loss of cargo. This loss of cargo eventually gave rise to GA dispute, which is the counterclaim which the respondent is contending here.
Madam, again, coming back to one question I asked your colleague. Suppose
Indeed, Your Lordship.
this shortage of cargo, evidence of whatever bad weather, whatever compelled the master to take a decision to dump the cargo. All these things. Suppose the evidence is best available here. Can the principle of forum non-convenience be applied to say that the better forum would be this court rather than the arbitral tribunal in London, because the best evidence is available here? Would that principle apply to arbitration? Where the parties have chosen, it applies no doubt to where the parties have chosen a particular jurisdictional court. So let us say the courts in London, instead of arbitration, the agreement was exclusive jurisdiction to the courts in London to decide any dispute. Principle of forum non-convenience applies where the better evidence is available. Some of the factors which compel the court to say, despite that jurisdiction clause, it can be maintained elsewhere. Would that apply in the case of arbitration also? The principle of forum non-convenience. Don't worry, if you're not aware of that principle, don't worry. I'm just trying to test your knowledge of, because one of the parameters we are supposed to test you on is use and understanding of law and international jurisprudence. That's why this question has come. But if you're not, if it is outside the moot problem, forget about it. It's not going to factor in our decision. But Just thought I would ask you to see if you have any knowledge of that principle.
Your Lordship, the council begs your pardon. The council may be wrong here, but as what to answer your Lordship's question about the doctrine here. As far as the knowledge of limited knowledge of the council goes, the court of appeal, the doctrine can be used as a defense to the enforcement of arbitral awards, but it's not a compelling criteria.
Yes.
If that is all the council.
Yes. Go ahead.
So now for the enforcement of for the enforcement of future international arbitration awards, this is a okay. Sorry, to rephrase, the doctrine of forum of non-convince says that it basically is used as a defense to the enforcement of arbitral awards.
Madam, it's simply, no, it's not regarding enforcement. It is principle. Now that we are on it, it is roughly translates into a more convenient forum on the basis of various parameters, such as availability of evidence, such other parameters, better enforcement. All these things are factors which will weigh with the court when faced with a plea that you don't have jurisdiction. The parties have chosen another jurisdiction of another court, exclusive, subjected themselves to the exclusive jurisdiction of another court. My question was, again, to put it again, whether that principle will extend to arbitration clauses also. Anyway, let's proceed. You go and proceed in whatever way you want.
Indeed, Your Lordship. To conclude the fourth issue, Your Lordship, the council submits that if the court decides to hear this case under 4F, then the court must look into the counterclaim of general average under 4Q as well. And that the counterclaim of the GA...
You need not bother on that. If the court were to hold that it has jurisdiction to consider the claim, it will certainly consider the counterclaim also.
Your Lordship, could you rephrase your question?
It's not a question. I'm just saying that if the court were to hold that it has jurisdiction to decide the claim of the petitioners, then it would necessarily have the right to adjudicate the counterclaim also. I don't think we would split it up and say for the counterclaim you go to arbitration, for this claim we adjudicate. Yes.
Yes, again, Your Lordship, because again that would be, you can't have selective jurisdiction.
Yes.
Indeed, Your Lordship. Now, if your Lordships do not have any questions, the council would like to proceed to the fifth and the last issue.
Yes.
Much obliged, Your Lordships. The fifth issue at hand is, do the provisions of the Arbitration Act exclude an action in rem from its purview as non-arbitrable? Now, for the fifth issue, the council argues that the provisions of the Arbitration Act do not exclude an action in rem from its purview as non-arbitrable. Your Lordships, the Arbitration Act by itself does not lay down any provisions that highlight the non-arbitrability of any dispute. However, over the years of judicial pronouncements on the subject of arbitrability have classified certain disputes as arbitrable and certain disputes as non-arbitrable. Your Lordships, actions in rem are traditionally considered to be non-arbitrable. However, it is submitted that this cannot be considered as a rigid rule, and it is argued that in the present case, the actions in rem should be brought within the scope of arbitration. Your Lordships, firstly, we must refer to the observation of the court in landmark judgment of Booz Allen and Hamilton versus SBI Home Finance, which clarified that it is not a rigid rule that rights in rem are non-arbitrable. Furthermore, Your Lordships, the rights in personam that are born out of rights in rem are considered to be arbitrable. If any dispute that relates to right in rem but gives rise to certain subordinate rights in personam, then such aspect of the dispute should be considered arbitrable. Your Lordship, the same can be corroborated by referring to page para 23, page 276 of the compendium submitted. This was held in Booz Allen case.
What decides arbitrability, whether it is a subject matter or is the cause of action? What determines whether something can be arbitrated or not?
Your Lordship, to answer that question, in Vidya Drolia, the court laid down three parameters to determine what decides the arbitrability of the subject. So the first parameter is whether the disputes are capable of adjudication by arbitration. That is, there can be disputes that can be resolved by an arbitration tribunal chosen by parties.
So what is the dispute here?
Your Lordship, the dispute in the present
Loss of cargo.
Yes, that
Under a contract.
That is giving rise.
Under a contract.
Your
Is
Lordship,
it not arbitrable?
Contract defined by the terms of the bill of lading.
Yes.
Your Lordship,
It's not distinct from the terms of the charter party. Is that not an independent contract? The terms of the bill of lading, is it not an independent contract? Not depending in any manner on the terms of the charter party, in which case the provisions of the charter party agreement, which provide that all disputes shall be settled by arbitration, do not apply to the contract created under the bill of lading. See, bill of lading normally contain conditions on its reverse. So this is settled law that the terms of the bill of lading are a contract between the parties, the cargo owner and the carrier who issues the bill of lading.
Your Lordships, the council understands what your Lordships are trying to put across. However, loss of cargo, which is the cause of action here, is an action in personam here, and an action in personam, and this is what the council is trying to contend, that if the subordinates' rights if the subordinate rights are action in personam, then such disputes are arbitrable.
Yes. Are you saying that the bill of lading in this case is an integral part or is to be seen as a part of the charter party agreement itself, because the parties are the same?
Your Lordship,
Because this would be essential for the court to hold that the arbitration clause extends to loss of cargo also.
Your Lordship's bill of lading is a legal document issued by a carrier to a shipper.
Yes.
And the council agrees to your Lordship's what your Lordship is trying to say, that it does indeed form an essential part of the agreement. However, squaring back, the cause of action here is loss of cargo, which is a subordinate right in personam. And
Normally, are you saying that normally bills of lading contain a dispute resolution clause also? You're saying that this bill of lading did not have a separate clause relating to dispute resolution only because it was covered under the terms of the
charter party.
charter party. Is that your case?
Indeed, your Lordship.
Yes.
Lordships, in the present case, we've seen that invoking this court's jurisdiction for the purpose of arrest of vessel, as mentioned in Moot proposition, page 3, last paragraph. Now, your Lordship, it is an action in rem, but the subject matters of the disputes are loss of cargo, as was reiterated by the council.
Without interrupting the court, let me remind the speaker that your time is over.
Sure. If your Lordships could grant the council an extension of 3 more minutes.
Yes.
You can sum up.
Yes, indeed, Your Lordship. Your Lordship, see, an action here, the action in rem was the subject matters of the dispute was loss of cargo and declaration of demand of GA, which are rights in personam. Thus, if we apply the aforementioned principle that was laid down in Booz Allen judgment, that any subordinate right arising out of a right in rem should be considered arbitrable, given that there is a valid arbitration agreement between the parties and the subject of the dispute is covered by arbitration clause. Now, both of these conditions are being satisfied according to the factual matrix. Your Lordship, thus the council submits that in order to determine the arbitrability of any dispute, this honorable court must first inquire whether there exists an arbitration agreement between the parties, and if there exists, and whether the dispute is purporting to an action in rem, which eventually gives rise to an action in personam. Now, Your Lordships, in the present case, there existed an arbitration agreement between the parties, which stated that all disputes shall be referred to arbitration in Lloyd's London. And the dispute was of such nature wherein the action in rem gave rise to an action in personam, that is, the dispute that is present before this honorable court. Therefore, the same must be considered arbitrable as per the aforementioned judicial pronouncement. If Your Lordships do not have any further question, the council seeks permission to proceed to prayer.
Yes.
Much obliged, Your Lordships. In light of the issues raised, arguments advanced, may this honorable court be pleased to hold that the exercise of admiralty jurisdiction by this court, despite the presence of an arbitration clause on the charter party, is not valid. Declare that general average is legally sustainable. Declare that the court considering this issue would be bound by the sanctions imposed by a third country. Adjudge that the rival claims cannot be adjudicated upon by this court even if the alleged damage occurred within its territorial waters. And declare that the Arbitration and Conciliation Act of 1996 does not exclude an action in rem from its purview as non-arbitrable. And pass any other order which the honorable court may deem fit in the furtherance of justice, equity, and good conscience. And for this act of kindness, the respondents shall as in duty bound ever pray. Your Lordship, may the present council also add that it indeed was an absolute privilege to plead before this honorable court.
Yes.
Your Lordships, for the rebuttal session, IMC 104 may take 5 minutes and IMC 113 may only take 1 minute as per the apportionment of time, since they've already exhausted a lot of time. So we'll start with the rebuttal session.
Your Lordships, may the council on behalf of the petitioners proceed with the rebuttals.
Yes.
Indeed. Your Lordships, the council would like to state a 4-pointer rebuttal to what the respondents stated. The first one being, Your Lordships, the respondent stated the new JSON clause. Now, it is important to note that the inclusion of new JSON clause by the respondent is invalid, because the new JSON clause is issued simultaneously with the bill of lading, and the Moot prop nowhere mentions that the inclusion of the said clause. Therefore, the contention based on the new JSON clause is purely assumption. Secondly, Your Lordships, the council also stated the Balco judgment. They stated that the Indian courts have no jurisdiction to grant interim relief over foreign-seated arbitration tribunals. Your Lordships, it is important to note here that the 2015 amendment of the Arbitration Act extended the provision of the Section 9's jurisdiction to foreign-seated arbitration tribunals. Your Lordships, the next one being, the council stated that the master of the vessel would have a total discretion over jettisoning the cargo. Your Lordships, the York Antwerp rules that have been included as per the Moot Court proposition state that only such damages are allowed under general average that would be permissible for general average contribution, and an exception of the same being the actionable fault. which means that the master does not have total discretion over jettisoning the cargo. And the fourth and the last contention being forwarded is that the respondent stated that as the prayer by the petitioner was under section 9 would mean that there would be a parallel proceedings and the petitioners have a malified intention. It is humbly submitted that, your lordships, if the court agrees to hear the present case on the basis of section 9, if the court accepts an interim measure, this would apply a stay over the arbitration proceedings in London, and the court would hear the present case, and there would be no parallel proceedings in that case.
Yes.
That is all, your lordships.
We may move on to the start rebuttal. IMC 113.
Your lordships, post 2015 amendment, section 9 of the Arbitration Act applies to foreign seated arbitrations. Now, section 9 is the power of the court to grant interim relief in arbitrations. Post 2015, that was extended to even foreign seated arbitrations. Yes, so your lordship, it does apply, but today the court is exercising a power, today the court is not exercising a section 9 power, as they didn't file a section 9 application. The court today is assuming jurisdiction under 4F and section 5 of the Admiralty Jurisdiction Act. Now, the counsel for the petitioners didn't invoke section 9 of the Arbitration Act, which deals with interim reliefs. The claimants don't want this as an interim relief. They are trying to run a parallel proceeding, which clearly shows their malified intention on their part. They want an arbitration as well as a parallel proceeding, so they can use any proceeding to their advantage. If they wanted an interim relief, they should have come under section 9. This clearly suggests that they wanted this court to see the case in merits. And herein the court is not today instituted to see the case in merits.
Yes.
Moreover, your lordship, to counter the opposing counsels.
IMC 113, your time is over.
Sure.
Yes. So how do we proceed now?
Since we've done with the rebuttal session and the sub-rebuttal session, it's time for tabulation right now. So participants may please leave the courtroom now, and judges may remain in the court.